Okay, so you found the house, you've agreed on the price, and now comes the part maybe everyone, well, dreads a bit. The conveyancing. Welcome to the deep dive. Today, we're trying to cut through the UK's legal jargon, that kind of mountain of paperwork around buying property. We're focusing specifically on the solicitor's role, their critical part in making sure the whole transaction is, secure.
Absolutely. It often feels like the least understood part, doesn't it? That sort of black box.
Exactly. So our mission today is really to uh, crack open that box. We want to pull out the key stages, the essential facts,
Yeah, help you get informed about what your legal guide, your solicitor is actually doing. Turn that paper mountain into something clearer.
actionable steps, hopefully.
That's the aim. The sources we looked at lay out a pretty clear timeline for this conveyancing process. It starts with investigating the title, then handling key documents, think mortgage deed, the contract itself. Then there's all the work the solicitor does before you exchange contracts. And finally, those crucial mandatory tasks after completion.
Right. It's about knowing what they're doing and, importantly, why it matters for your big investment.
Precisely.
Okay, so let's start with the basics. Who are the people actually running this process? We hear solicitor and licensed conveyancer. Are they basically the same thing for buying a house?
For practical purposes, often yes. We'll probably just say solicitor mostly today, like the source material does, just for consistency. But there is a difference.
Okay.
A licensed conveyancer has specific qualifications, specific training, and they only deal with property matters. That's their entire focus. A solicitor, on the other hand, is qualified more broadly in law.
But for just moving house, either should be fine.
Oh, yes, absolutely. Both are highly qualified for property transactions.
And their role isn't just like shuffling papers, is it? It's more advisory.
Definitely. They're advising you throughout, especially on things like, are there any issues with the property's title? What about the mortgage details? And importantly, making sure you've got buildings insurance lined up before you complete. Contents insurance, too, usually.
And one thing to note, those solicitor fees, they start racking up as soon as they start working right. And some costs, like paying for searches, you won't get back if the purchase falls through.
That's right. Things like title searches or local authority searches, once they've paid for that service, that money's spent, it's non-refundable generally. It's a cost incurred early on.
Okay, good to know. Now, that advisory role, it comes with serious responsibility, doesn't it? This duty of care idea.
Exactly. It's a professional duty. If they're negligent, say they miss a major problem with the property's legal title and you lose money because of it, you can potentially sue them in civil court.
Wow. So how does that risk get managed? How are buyers and lenders protected if a mistake happens?
Well, firstly, you'd have to actually prove they breached that duty and that you suffered damage as a direct result. But the big safety net is professional indemnity insurance.
Off the insurance.
Yes. Solicitors must have it. It's not optional. It means that if a court awards you damages because of their mistake, the insurance is there to make sure you actually get paid.
All right, so there's a fund to cover it. That sounds like a pretty strong reason for them to be diligent.
It certainly focuses the mind.
Before we get into the main process, the sources mentioned something interesting, a regional thing in Scotland. Solicitors sometimes acting as estate agents, too.
Yeah, that's right. Particularly in eastern Scotland, you find some solicitor firms who do both the legal work and act as the selling agent.
Really? How does that work?
Sometimes they even run joint property centers where they list homes for sale. For the seller, the vendor, it can actually save some money because you're sort of combining those services and fees. Streamlines things a bit.
Interesting. Okay, let's get back to England and Wales then, and the main timeline. After your offer is accepted, the first big legal step is the investigation of title. Sounds important.
It is the most important step, really. This is where that duty of care really kicks in. The solicitor has to make really thorough checks.
Checks for what, specifically?
3 main things. 1, is the person selling actually the legal owner? 2, is the property legally described correctly? Is it what you think it is? And 3, are there any hidden restrictions or rights affecting it that could cause you problems later?
So they're digging deep to make sure everything's legitimate and clear.
Precisely. And the end result of all this digging is something called a certificate of title.
Okay, the certificate of title. What does that actually mean for me, the buyer? And I guess for the bank lending the money.
For you, it's the solicitor basically saying, yes, professionally, I've checked this and the title looks sound. It's crucial because if they miss something, you inherit that problem.
Right.
But the lender, they care possibly even more. Any defect in the title, like a hidden right-of-way or an old charge, could affect the value of their security, the property itself.
Because if I defaulted, they might not get their money back easily.
Exactly. So the lender will absolutely insist on getting a satisfactory certificate of title before they'll agree to release the mortgage funds. They won't proceed without it.
Makes sense. But what if the title isn't perfect? Sometimes records are old or messy. Can they still proceed?
Sometimes, yes. If there's a minor issue or a potential risk they can't fully resolve, they might recommend insurance against defective title.
Ah, another insurance policy.
Sort of. It's a specific policy designed to cover financial loss that might arise from a hidden title defect that wasn't or couldn't be identified during the investigation. Things like unknown covenants, maybe an access issue, different types of historical title problems.
So it protects the lender mainly.
It definitely protects the lender. Often it protects the buyer and future buyers, too. It's a way to manage risk when the legal title isn't absolutely crystal clear. A pragmatic solution.
Okay, that makes sense. Now, you mentioned the solicitor makes thorough inquiries and checks. Let's unpack the practical side of that. The searches. What does carrying out searches actually mean? The sources list about 5 key ones.
Right, the searches. This is the legwork of the title investigation. They involve contacting different official bodies to get specific information about the property and the land it sits on.
Which one tends to uncover the biggest potential future headaches? The nasty surprises down the line.
Oh, that would definitely be the local land charges registry search and the associated local authority inquiries. That's the one that looks forward.
Looks forward? How so?
Well, this search flags up things like, are there any major planning schemes approved nearby? Are there plans to build a new road right past your garden? Are there existing planning conditions or environmental health notices attached to the specific property? Maybe tree preservation orders or conservation area restrictions, things that could stop you doing what you want with the property later on.
Ah, like finding out you can't build that extension you were planning because of some council rule you didn't know about?
Exactly that kind of thing. Knowing about those potential restrictions before you buy is critical.
Okay, so focus on that. Local authorities search for future proofing. Got it. What about the other main searches? Let's quickly run through what they're checking for.
Sure. If the property is registered land, which most is in England and Wales now, the main one is the land registry search. That checks the official title register who owns it, what mortgages are registered against it, any rights or covenants noted there.
Simple enough. What if it's unregistered land? Does that still happen?
It does, though it's becoming rarer. For unregistered land, they do a land charges registry search. This looks for specific types of charges or interests that wouldn't be in the old paper title deeds. Things like puny mortgages or spousal interests.
Okay, hold on. PD mortgage, spousal interest. Can we simplify those?
Right, jargon alert. A puny mortgage is basically a second or subsequent mortgage on unregistered land where the lender doesn't hold the actual paper title deeds as security. It's registered as a charge instead. Historically, a bit riskier for lenders.
Okay, a kind of hidden debt attached to the land. And spousal interest.
That's where a husband or wife who doesn't legally own the property has registered a legal right of occupation under the Family Law Act. It means their consent might be needed for the sale. Again, something crucial to uncover.
Got it. Hidden claims or rights. What are the last couple of searches then?
There's the bankruptcy search. Pretty straightforward. They check if you, the buyer, are bankrupt. Sometimes they check the seller, too, just to make sure they're entitled to receive the money from the sale.
Makes sense. And the last one?
The Commons Registration Search. This usually only applies if you're buying property in the countryside or maybe undeveloped land. It checks if the land is registered as common land or perhaps a village green. If it is, there are usually significant restrictions on how you can use it.
Right, so probably not relevant for most city or suburban house purchases.
Generally not, but it's on the checklist for thoroughness.
That's a lot of checking. Now, the sources mentioned a potential shortcut, but only for remortgages, skipping searches.
Yes. If you're just remortgaging your existing property, not buying a new one, the solicitor might arrange something called search indemnity insurance instead of doing all those searches again.
Why do that?
It's quicker. The insurance protects the new lender against any problems that might have been revealed by searches had they been done. Because you already own the property, the risk profile is different. It can shave weeks off the remortgage process.
Okay, so a time saver for remortgaging, but not for a purchase. Good distinction. Right, so all the digging, the searches, the title investigation is done. What's next? We're moving towards exchanging contracts now.
Exactly. Before you get to exchange, there's some key paperwork and communication, especially involving the seller, the vendor.
What does the vendor have to do?
They have to fill out a standard form, usually the Law Society's Property Information Form, the TA6. It covers a whole range of things about the property: boundaries, any disputes with neighbors, guarantees for work done, environmental matters, and critically, what's included in the sale.
And they have to be honest on this form.
Absolutely. They have a legal duty to answer truthfully and accurately. If they knowingly give false or misleading information and you rely on it to your detriment, you could potentially take legal action against them later, even after you've bought the place.
Okay, that's important. Now, this form also tackles something that causes endless arguments, doesn't it?
Mwah.
Fixtures versus fittings.
Ah, yes. The classic source of disputes. It seems minor, but it can really cause problems if it's not clear.
So what is the actual difference we need to grasp?
It basically comes down to how attached something is to the property. A fixture is considered part of the land, part of the building itself. Think built-in ovens, integrated appliances, maybe a fitted wardrobe screwed to the wall, central heating systems.
Things that are physically attached.
Right. And the rule is, fixtures are included in the sale unless the contract specifically says they are excluded.
Okay, so fixtures stay unless stated otherwise. What about fittings then?
Fittings are personal belongings, sometimes called chattels. Think curtains, carpets, usually though sometimes debatable, freestanding washing machines, furniture, pictures on the wall.
Things you can just pick up and take with you.
Exactly. And the rule for fittings is the opposite. They are not included in the sale unless the contract specifically says they are included.
This is where people get caught out, isn't it?
Yeah.
The sources give a great example. You view a house, see amazing designer light fittings and lovely fitted wardrobes. You just assume they're staying.
And then you move in, and there are just bare wires hanging from the ceiling and empty spaces where the wardrobes were.
Nightmare.
It happens, even if something looks very permanent, like a bespoke shelving unit. If it's technically a fitting and not listed in the contract as included, the seller can legally take it. That TA6 form and the final contract need to be absolutely explicit about which specific items are staying and which are going. Your solicitor should check this carefully.
Nail down those details. Okay, once that's all clarified, the solicitors get busy drafting the main legal documents.
Yes. Two key contracts emerge at this stage. First, there's the mortgage deed. That's the formal legal agreement between you, the borrower, and your lender, setting out the terms of the loan secured on the property.
The agreement with the bank.
Correct. And second, the vendor's solicitor prepares the draft sales contract. This is the big one for the transaction itself. It details everything: the agreed price, the deposit amount you'll pay when you exchange, names of buyer and seller, the exact property details, and all the terms and conditions of the sale, including that list of fixtures and fittings.
Right, the blueprint for the entire deal. Okay, fast forward. Contracts exchanged, completion day arrives, you get the keys. Is the solicitor's job done then?
Not quite. There are still some crucial administrative tasks they must do after completion. Mandatory stuff.
Okay, what are they?
The first one is extremely time-sensitive, dealing with stamp duty land tax, or SDLT.
The property tax.
Exactly. The solicitor has to calculate the amount due, submit an SDLT return form to HM Revenue and Customs, and pay the tax on your behalf. And the deadline is tight. Just 14 days from the effective date of the transaction, which is usually the completion date. Miss that deadline, and penalties and interest start accruing immediately.
Well, 14 days. Wow, okay, so pay the tax. What
Next, they need to officially register you as the new owner. They apply to the land registry to update the title records. This formally transfers ownership into your name.
Makes it official.
And crucially, at the same time, they register the lender's mortgage against the property title. This publicly records the lender's financial interest and security in the property.
So everyone knows who owns it and who has lent money against it.
Precisely. And the final step.
The bill.
The final bill, yes. They'll send you a completion statement and their final invoice. This will cover their own conveyancing fees, obviously, but also all the disbursements.
Disbursements. What are those again?
Those are all the costs the solicitor paid out on your behalf during the process. Things like the fees for those searches we talked about earlier, the land registry registration fee, the electronic money transfer fees, and of course, that stamp duty payment. They itemize everything they've spent for you.
Right, so it all gets tallied up at the end.
It does.
Okay. This deep dive has really, I think, shone a light on just how much detailed legal work goes into buying a property. We've gone from understanding the solicitor's role, their duty of care,
Through the vital title investigation and those 5 key searches,
cleared up that sticky fixtures versus fittings issue.
and landed on those strict post-completion deadlines, like that 14-day SDLT rule.
It shows it's far more than just filling in forms. There's a huge amount of diligence required to make sure the transaction is secure.
Absolutely. The whole process, all that meticulous checking and paperwork, it's fundamentally designed to protect everyone involved. It ensures the lender's security is sound, but ultimately it's about making sure that you, the buyer, legally own what you think you've bought, free from nasty, hidden surprises or restrictions.
You get what you paid for, legally speaking.
That's the goal.
Which brings us to a final thought for you, our listener, to mull over. The sources really hammer home the point that pulling out of a purchase after the legal work has started gets expensive quickly. We mentioned non-refundable search fees. But think beyond that. Once your solicitor really gets stuck into investigating the title, drafting contracts, maybe commissioning specialist reports based on survey findings, what are the real financial risks you're committed to at that point? How much solicitor time, how much disbursement cost are you potentially prepared to write off if the deal collapses before exchange? That feels like the true point of financial commitment to consider as you start down this road, something to think about.